Well, welcome everyone to what is our first webinar of the week as part of Smarter Legal Week. My name is Aaron Dunn and I'm joined by Chris Hill, who's the Principal at Hill Legal. G'day, Chris, how are you?
Good to see you again, Aaron. Thank
Well,
you.
this was a bit of a brainstorming idea, Chris, between the two of us when we were thinking about, would be great to talk about this topic, and then it'd be great to talk about that topic, and then what about this topic? And then we sort of thought, well, we either kind of put all these together over the course of maybe 6 months, or one of the things we thought we'd do was, why don't we actually kick off our a week of training around the legal support that we have available with our Smarter SMSF documents. And many of you will be well aware as well that Chris has been working with me and Ian, who is obviously one of the co-founders of Smarter SMSF, for some period of time. So the idea about Smarter Legal Week is to share with you a whole range of topics that come back to the deed and the way in which we have developed documents and content on the Smarter SMSF platform as well. And where else would we start? But we start at the SMSF deed, which is all about, of course, the engine that drives our SMSF clients and our SMSF strategy. So, Chris, today we are going to talk about the 7 must-haves within the SMSF deed. And before we kind of get stuck into that, I'd really like to get you to talk to our audience today about the importance of the deed. And I've already referenced the fact that it acts as the engine for your clients. And why is that actually the case?
Yeah. Well, an SMSF is basically at its roots is a trust, right? And like any other trust, whether it's a family trust or a bare trust, it's the trustee that governs the rules of the fund or the operation of the trust. And in your analogy, it's very much like an engine, and not one engine suits every vehicle. And so as such, and this is certainly the case when the issues with SMSFs go before the court, it's very much a black letter law situation. The courts look at the terms of the deed. And so, you know, as we see here on the screen, older deeds can create conflicts with newer deeds. There's questions of interpretation and, of course, questions around, you know, how the deed interrelates to the Constitution. And of course, with all this different changes in the superannuation laws, it's important that the deed speaks to those changes, and to the extent that those changes are permissive, that the deed addresses all of those changes.
Yeah, absolutely. And so as we go through today, the idea behind this is to start to highlight things as practitioners that you need to be looking for. So we know that it kind of seems to be like every decade that you go through major reform that requires a sort of a whole of client review of those deeds. And we know that that happened around 2017, and we know that it happened in 2007 as well. And not to say that 2027 is going to be the next one, but we know that there are ongoing things that require us to give due consideration to this particular topic. And now more than ever, we continue to see things evolving. And part of that is because we have, in my view, a much more diverse client base. So we see much younger entrants coming into the system, but we've actually got more older SMSF members than we've ever had before as well. So the diversity of that age group, the diversity of how they invest, and the diversity of what can be done in the fund means that we do need to be spending more time and attention to our clients' SMSFDs to ensure that they can do the things that they intend to do and want to do, and then manage the risks around those things as well. So in terms of answering those specific questions around the bottom, how often is really going to be subject to the change that we see in the law, but ultimately the change then we may see in the impact of certain court decisions. And I know the Hill and Zuda one was certainly in that case as well. So the other part that I just wanted to highlight here, because I know I just made reference to that 2017 period, and people go, well, I changed it then, and has there really been a lot that has changed since that period of time? Well, this here just highlights some of those ongoing changes that we have seen. one of the common ones I talked to people about was, well, we have a change that happened and we might have got those client deed updates in that 2017 period, but very quickly thereafter, so within a 12-month period, when people may have done those updates, we then saw downsizer contributions come in. So the ability for, and I know this was certainly the case with the changes that we made in 2017, we then needed to make further updates in 2018 to accommodate for those changes, and therefore the ability to do a downsizer contribution needed a further update at that point in time. So I guess as we sort of look at the bottom of that previous decade and then on the right-hand side to the current decade, there are a number of changes still right now that would mean that if you are looking at and currently have a 2017 deed, there are arguably some important changes in here that you would need to make sure we actually have covered off in here. And whether that is, that increase from 4 to 6 members. Now that again comes back to whether the deed is prescriptive or just allows for the fluid nature of the definition change with SMSFs. The introduction of electronic execution measures is obviously quite significant there. Changes around the work test requirements for contributions, director IDs, as we know, that has come into place with our company requirements, and then, of course, the ever-growing number of case law decisions around superannuation death benefits. So these are all elements that we have seen evolve over the past sort of 5, 6, 7 years. And again, we'll highlight many of these things available to you today. So Chris, is there anything else in there that you wanted to sort of comment on before we get stuck into our 7 must-haves?
No, just that we're going to have the 296 tax coming into operation. So that'll be another change.
Yes.
And of course, there's a lot of debate and discussion around that at the moment with the SMSF Association around various elements of that. Of course, when that comes out, that will necessitate changes to the deed as well.
Yeah, and I think that's a good point because, we might see providers sort of talk about, well, it includes the requirements of Division 296 measures. I mean, the reality is we have no law yet, and and it continues whether the current way is going to apply or not. So again, we are very closely attuned to what is going to happen, and then when we know if and when that law and the construct of that law will operate, well, then at that point in time, we'll look to make those relevant amendments as well, and then consider the impact of those for your clients. So let's get stuck into our must-haves in our SMSF client deeds. And I think, Chris, the first one that we want to touch on here is around the instructions and with the payment of superannuation death benefits and the requirements around binding death benefit nominations. Because Hill and Zuter, I know you and I actually ran a session around the Hill and Zuter decision at that point in time. And many of our audience will know quite clearly today that we don't look to the requirements of the regulations when it comes to binding death benefit nominations with SMSFs, but rather we have to go to the rules of the fund. And that decision in Hill and Zuter was effectively the decision that was affirmed. And the ATO's views have simply been that going back to 2008 as well. But one of the things that we commonly see with SMSF deeds is that we have this construct of where the regulation gets imported back into the deed. So can I get you to sort of comment on that a little bit, please?
Yes, and in fact, the Donovan case that you've got there is a classic example, because what that case said, what that deed said was that the requirements of 617, the death benefit nomination had to comply with the requirements of 617A. And this shows that, and as part of the legal review that we're seeing now, a lot of older deeds simply just take what I would call the lazy approach and simply adopt 617A, even though we know from Hill and Zuter that it doesn't automatically apply to an SMSF. And that's been the view for quite some while, certainly from the ATO. So, but we still see deeds that do what has done in Donovan, and that is import 617A, which means that even though you've got the freedom of Hill and Zuter, we're bound by the terms of the deed, coming back to our earlier point. So that underlies the importance of reading the deed and the terms of the deed, and whether the death benefit nomination conforms with that. And certainly with deeds, when they get upgraded, they don't they might be written in a different format, but the terms of the deed require the adoption of 617A.
Yeah, and Chris, the other part there, I think, to that bottom point is just the importance of procedure with this as well. So, yes, we might see the importation of 617A, or we might be doing it in accordance with, we think we're doing it in accordance with the deed, but making sure you've dotted your I's and crossed your T's at this point becomes crucial as well.
Yeah, and that might mean providing evidence, if required by the deed, that the notice has been served on the trustee. And where the registered office of the trustee, and I think we saw that in Perry and Nicholson, that the office of the trustee, if there was a requirement to serve, that the nomination has to be fulfilled, otherwise it won't be binding. So those procedural requirements are critical to the validity of the death benefit nomination.
Yeah, absolutely. Well, let's have a bit of a discussion here, Chris, with the Smarter SMSF deed around what we've done in the context of the nominations. And I might get you to talk about this, because I know over the past couple of years, we've done some very specific things in here off the back of not only Hill and Zuda, but a number of other cases in recent times. So I might sort of kick things off that set out, I guess, in Rule 11.1 here, the types of nominations that can occur. And we have in there quite clearly, a statement of wishes or a non-binding nomination. But then we have the concept of binding nominations, again, whether you want those to be lapsing and you can prescribe that time frame for that to lapse, or you want it to be a non-lapsing nomination. So those forms are both available there in terms of the lapsing and non-lapsing, and then the concept of the SMSF will as well. So we, in essence, allow for all forms in the way in which the nomination can be provided. I might get to elaborate a little bit more about that then goes into the timeframes, validity notices, who can make it, et cetera, et cetera.
Yeah, and I think this is what this is designed to do, or what this clause is designed to do, is to allow people to have flexibility in dealing with their death benefits based on all the variety of circumstances. And of course, the SMSF will, which has been described to be a death benefit nomination on steroids, often said, is again another way a member can provide written directions about how their death benefits are to pass more specifically. And the classic case there would be dealing with business real property or the assets of the fund to be transferred in specie, either to the estate or to an individual, maybe setting up accounts-based pensions or income streams for infant children or children under 25, or creating terms or conditions in relation to the payment of the death benefit. All of these things can be part of the suite of options for the advisor when having these conversations with the client. And of course, a lot of these conversations are in the context of a death benefit and in the wider concept, an estate planning conversation.
And one of the other things we can see here in Rule 11.2, which we did a change not that long ago, was around the fact that that notice, so that direction being provided by the member, there may be some stuff within that document that they might not want the other trustee to become aware of. So we've allowed for some additional period of time for that notice to be served, which can naturally include at some time by their legal representative after they've passed away.
And that's a good point. And this is going to apply a lot to blended families, where there is tensions within the family about how their estate is to be divided, or in this case, their death benefits. And sometimes those issues, there's a degree of candor that's required or discretion about what gets said or how it gets revealed. This allows the member to make those decisions without having to physically give notice to the other trustee, which is usually a spouse or partner.
Yeah, absolutely. So a couple of other things here then, we obviously talk about the form in which we provide this. So we do have within our current deed, both an Appendix 1 and Appendix 2 that outlines obviously the way in which the nominations need to be followed. But there are then, I guess, a whole range of other ways in which or I guess things that need to be considered as part of this as well. And again, Chris here, Rule 11.5 describes the manner and form in which the death benefits will be paid based upon the direction that's happened, and obviously the consideration of things like insurance and whether it can be paid as a pension and whether it can be paid as a lump sum. And then ultimately we come down to the process that binds the trustee to be able to comply with those directions, and in the event of any conflict or some sort of form where there may be a level of invalidity to that notice, then the way things need to be treated in that regard as well. So I guess any other sort of final comments we just want to make around Rule 11 when we think about the way in which death benefit nominations can be put forward, and why people need to really drill down on their SMSF deed around the construct of the payment of super death benefits.
Well, I guess the point that comes out of this is that because we've provided so many options here, which is, again, about making the shoe fit the foot, so to speak, for the member, it's important for advisors to read Rule 11 in the context of their clients' needs, not one size fits all.
Yep.
And because we've now got non-lapsing, binding, non-binding, lapsing, non-lapsing nominations and SMSF wills, there's a whole suite of options available to the advisor and having conversations with their client to make sure that the best option fits that client.
Yeah, and it's probably a good point to raise here as well, Chris, which is why we put the guides in as well. So where we've got the information in here is more specific to the actual rules, but within every rule, we actually have a guide that actually helps to articulate what the outcomes of those rules are. So the guides are not binding on the trustee, or if it's in a court of law, but it's there to provide guidance in respect to what the rule is intending on doing.
Yeah. And I would advocate that this should be part of a broader conversation with the client about their estate planning, because how that super death benefits pass, whether it goes to a beneficiary or to the estate, is part of that conversation in conjunction with the provisions of the deed and these options.
Yeah, absolutely. All right, well, let's move on. And speaking of obviously an area of importance when it comes to binding death benefit nominations, because this is an area that we can utilise as part of that concept of paying super death benefits. But this is what we call the concept of a special rule of the fund. And again, this is somewhat unique to the deed, and quite often we will see this rule being utilised by many of the members ordering on our Smarter SMSF site. And it allows for things that are effectively allowed within the fund, but are not specifically prescribed within the deed itself. So we know that the deed sets out rules around who can be a member, the powers that the trustee may have, the fact that we can create a superannuation interest for a member, whether that's in respect to a pension or an accumulation interest, how contributions are made, how other benefits are paid. Now, what we ultimately try and achieve with the Smarter SMSF deed is we want to ensure that the deed covers what the law allows us to do, but we don't want it to be too prescriptive, so that every time there's a change, you need to go out and actually make a change yourself to the client's deed. So what we then try, and a good example of that probably is the concept of what we call an authorised contribution. So it's a contribution that would ordinarily be allowed under the law. So we didn't need to make adjustments with that age 65 or 67 through to age 75 concept that changed a couple of years ago about being able to make contributions. So in that context, the less prescriptive around that, the better it is. But we then also know that there are some other fund and member-based events that the documents need more detail. So, and a really good example of that is around pensions. So outlining this more specifics of how the pension will operate. But what we note here is that document that is being prepared would benefit from being annexed to the fund as if it had been formed as part of the deed itself. So Chris, what I'm going to get you to do here is just to talk through this concept a little bit and why we've actually put this in place and how it fits into the deed more broadly.
Yeah. So the idea, I guess there's two features or two benefits of the special rule. bearing in mind that we have a proportionate rule or an accounts-based valuation rule for decision making. The idea of a special rule is, as you've mentioned, Aaron, is to effectively hardwire other documents outside of the deed as if they were rules of the fund or binding into the written into the trust deed. And the Hill and Zilda is a classic case where effectively a form of nomination was, or death benefit nomination was actually hardwired written into the deed.
Yep.
So that's what we've done with the special rule, and this would apply to an SMSF living will, death benefit nomination, SMSF will, an SMSF enduring power of attorney, which we're going to speak more of on Wednesday. But the other element of this is that the rule can't be changed without the consent of the relevant member. And the idea of this is to create a document outside of the fund that can be bound into the fund that can't be altered or overwritten based on the proportionate voting powers, but without the consent of that member, who may or may not have a majority power. And so this is very well used or very useful in the case of death benefit nominations or SMSF wills, that the fund can't undo that document when it's written into the fund without the consent of the member. And obviously their consent can't be provided when they've passed away.
Yeah, and that's also the case, and I think it's common that we see it around pension commencements. So in particular, if you're going to nominate a reversionary beneficiary, so the fact that the individual member may have obviously commenced that pension and within that pension may have stipulated certain things to occur, the fact that that then can be chosen under the Smarter SMSF deed to become a special rule of the fund puts those adequate protections in, like you spoke about, Chris.
And probably just to add to that is if some pensions, maybe because we have an excess transfer balance, some may want to revert, some may not want to revert. So again, it's about allowing the member to have control about how that excess transfer balance is going to be managed through an existing income stream.
Yep. And the other part that I guess we have also added into this, and I think it was 2017 that we did this, is the concept of the paramount document as well. So not only can we decide to annex that document as a special rule of the fund, but we can actually choose to treat that as what we call a paramount document. And effectively, it allows for that document in the event of any conflict around the validity of that document to outrank any other document that may be in conflict with it. So, Chris, anything else you want to add just around that concept as well?
I think yes, we came up with this concept because around the time there was this debate in the industry whether a death benefit nomination trumped a reversionary pension, right? And you know, and of course it came back to the terms of the deed. Some deeds were unclear. So we created this idea of a paramount document because there were some circumstances where we wanted the pension to overrule the death benefit nomination and vice versa, or part of the pension, as we've just spoken of. So the paramount document concept allows us, or allows advisors to choose which particular document overrides another document if there are more than one.
Yeah, absolutely. All right, well, let's keep moving on. So the next bit, which is clearly related to this area, as we're talking about many of our older clients here, and the fact that the risks around incapacity are as alive and much a reality as they are around the payment of superannuation death benefits. So many of you will be acutely aware of the requirements within our definition of an SMSF and the fact that there are some exceptions that allow for another person to come in and step into the shoes of that member where they have a legal disability or where they effectively hold an enduring power of attorney for that person to be able to act as the representative of that individual. Equally, when a member dies, again, there is a permissive function to allow for the LPR again to come in to be appointed to enable the payment of those superannuation death benefits. But I do include a very important point there, and that is that it is permissive, and I use that word very specifically, because it is a permissive function within 17A, not a mandatory function to do so. And again, understanding those nuances become really important, and why we have those sort of questions as part of the death benefit nomination and the construct of things like binding death benefit nominations. And then finally, as you can see on the bottom bullet point, is just making sure you understand what the member actually wants to occur in the event of incapacity and death. And Chris, this is an area that you kind of live and breathe every day. So just again, I'd be really interested in some comments from you here about, you know, what you see each and every day, and how trustees are giving and members are giving consideration to some of these succession plans, in particular with the type of assets, the type of balances that we have within the funds.
Yeah, well, this is a bit of a plug or a summary of what we're going to discuss more on Wednesday.
Yep.
But essentially what we're seeing in the community is increasing dementia rates. We're seeing elderly, which is a consequence of an older population of clients, and all of our viewers will be experiencing that within their client bases. And the desire by clients to want to have more say or control about how their death benefit or how their super benefits are managed during that period of incapacity and before they pass away. As we know, once an LPR steps into the role of trustee, they're not bound by the terms of their LPR document, the enduring power of attorney. So what we've done, and it's a feature of the deed here, is the ability to control how assets are managed during a period of incapacity, and how you as an advisor can play an important role in that function without being a trustee.
Yeah.
And we'll speak more about that on Wednesday.
Yeah, so again, going specifically to some of the rules that you can see in here, we talk here about that role of legal representation. So ensuring that there is alignment between the representative coming in and who that replacement trustee is. And I think, Chris, here, the other point that's worth noting is the conflict that can then occur with this if we don't actually have our constitution. And I'm just going to reference here because we know, you know, 80+% now probably have corporate trustees in place, but how important it then becomes that if you are making these changes in respect to fund rules, that we've got alignment to the constitution that actually runs the fund as well.
Yeah, well, and of course the constitution governs the day-to-day decision-making, right? So how that constitution manages conflicts in decision-making, incapacity, replace, you know, directors, alternate directors, must fit with the deed. Otherwise you'll end up with a conflict potentially between the terms of the constitution, if it's just an off-the-shelf constitution, and the terms of the deed, which can end up in court, right?
Yep. Yeah, and different voting decisions that can happen around that, like you said, whether it's a product of member account balances versus something else. So just, yeah, I think that would be my other recommendation here, is that if you are looking at deed upgrades, making sure that you have absolute alignment between those two, because it will become more and more important as time goes on, due to issues of succession like we've spoken about here. I also raised the concept here in Rule 2.9 about this difference between permissive and mandatory obligations to appoint the member's legal representative here. So again, going somewhat back to the discussions we had earlier around the special rules of the fund and also the paramount documents, we give the opportunity for the individual in the event of their death around a binding death benefit nomination as to whether they want to have a replacement trustee appointed or not. And Chris, I might get you to maybe just provide some context here as well, because I think the most important thing to note when it comes to this sort of topic is there will be circumstances whereby you absolutely want to appoint a replacement trustee, yet there'll be other circumstances where it probably doesn't matter because the person that may be remaining is also the beneficiary in the fund as well.
Yeah, and look, most deeds just by default make the LPR or the executor as the replacement trustee. But as we saw with in the case of Dawson, where the attorney, the power of attorney that was the replacement trustee remained in office, you have this conflict between well, who's going to deal with the death benefits? Is it going to be the executor or the attorney was previously in office? So having the ability to choose your replacement trustee, which may or may not be the executor, again, gives more flexibility to the client in how to, deal with their death benefits. It might be dealt with separately. And this will be particularly the case where you have blended families.
Yep. So there's a quick question here, might be worth just raising. So if we've got one member fund and is a director of the trustee company along with their son, i.e. two directors, the member loses mental capacity, can the holder of the EPA step in place of the member to make the director decisions of the fund along with the other existing member, or because it is a company, they need a company POA?
Well, to fulfill the requirements of being a replacement trustee, you'd have to step into the office of director of the company, and the member, the disabled member or the incapacitated member would have to step down. And on Wednesday, we'll talk more about how do you force that situation, because it's a difficult situation when people don't want to step down. But to answer that question, you would need to step up into and that's where the Constitution wouldn't have to speak to the deed about that process, because that's a requirement to satisfy the requirement, says 17A, which, as you say, is permissive. To meet that requirement, to avoid the fund losing its complying status, they need to step into the office of director of the corporate trustee.
Yeah, and the other thing there that's just worth noting is that it needs to be an enduring power of attorney. So that is a requirement within our definition if we go back in 17A3. And then the other part just worth noting is really going back to, well, what does the Constitution require? If we're looking at a standard trading entity, the considerations of a member losing capacity and having their LPR appointed are pretty much non-existent, because that's not really what's designed to happen in in an ordinary trading company. Whereas when you look at the specifics of a superannuation only trustee company, well, all of these sorts of considerations very much sit front and center to make sure there is the relevant succession that actually happens. And it is very unique to the SMSF industry as well, because if a member loses capacity in respect to being a member of Australian Super or CBuzz or at a Colonial First State Fund, it doesn't impact the trusteeship of that RSE trustee, yet it does with SMSFs. And this is why this one area I know that the government is taking a closer look at around retirement in superannuation. And I know in the discussion paper that was issued late last year, these are all things that they are focused on, in particular around the retirement income covenant, whether it should be relevant to SMSFs as well. All right, well, let's keep moving along. And the other part to this, and Chris, we're going to talk about this in more detail on Thursday, but it is around the concept of a fund guardian. And you spoke just a second ago about the fact that when we have clients that start to lose capacity, there is somewhat of a challenge to get them to accept that that's the case, and it can create some real problems. Certainly one of the avenues that we can look to utilize here is this role of a fund guardian.
Yeah, and it's usually because the client in many cases has this very strong relationship with the advisor, that are viewers today, and wants them involved in some of the decision-making process when they lose capacity, maybe because they don't trust their EPOA, maybe there's conflict in the family, maybe they don't have the financial skills to be able to manage their super, or there's concerns about how it might be mismanaged. But of course, the biggest problem for most advisors is, well, I don't want to be a trustee. I can't charge for that office. I'm not going to be insured for that role. The fund guardian is a way that the deed allows here to allows the advisor to play an important role in managing a whole bunch of issues, and we'll be talking more about that on Wednesday and Thursday, of course.
Yeah. And yeah, so I think some of the main ones here really do come back to that definition, like you said, the fact that the requirement under Section 17A is restrictive around remuneration, and we know that there would be other circumstances, whereas you're a financial advisor, there might be an AFSL limitation for you being able to do those things as well. So therefore, it really comes back to, well, how do we actually be able to take a position as the trusted advisor for our client? And this is where we effectively we really probably need to give credit to Ian to this originally, that he created this concept of a guardian that sat outside of the role within Section 17A of being able to be a trustee of the fund, in essence, but it gives that guardian the ability to ring fence certain things that a trustee may or may not be able to do.
Yeah, and we'll speak more a bit on Wednesday about their veto powers, their consent powers. So it allows the advisor to sort of take a supervisory role, put it that way, of the activities of the APOA when they become a trustee, and play an important part in the management of their affairs, given that you are the trusted advisor for the client and have been for many years in many cases.
Yep, absolutely. So a couple of things just noting there again, about the process for the appointment of that role. So is it to apply immediately? Is it to apply maybe at a particular point in time in the future? Quite clearly, the point of incapacity is a relevant point there. And then also at what point in time that role would cease as well. So again, we're going to spend more time looking at this on Thursday as to why we think the role of the guardian is really underutilized in the context of SMSFs, and in particular as our clients are getting much older as well. So Chris, let's keep moving on, and we're up to our fifth now of 7, and this is an area that we've both done a lot of work on over the last few years, and that is the concept of electronic signing, noting that we've seen COVID really transform the way in which electronic communication is used in everyday life. Now, yes, we were doing Zoom and Teams meetings somewhat before COVID, but this is just the modern day of how we do things, and a great example of what's happening. Now, in the context of, in particular, electronic execution, understanding how this can be used, and specifically with SMSFs, is really crucial here, because it is still not accepted in all circumstances. We've got more flexibility in how these rules work within the Corporations Act and within the Income Tax Assessment Act, but they have not yet been finalised by government in respect to certain amendments that will apply within the SIS Act. And then it comes down to, well, what does and what can we do subject to the rules of the fund itself? And if we think about things like applications for membership, if we think about the ability to create a pension, these are all certain things that occur by operation of the deed, not what the SIS Act or the Tax Act or whatever might actually say. So therefore, it becomes really important that we have rules set out within the deed that make it abundantly clear that we can apply the execution of these documents in a technology neutral way. So Chris, you maybe just want to add a little bit of context around that as to what we did within Rule 30 here to allow for a technology neutral approach to the signing of certain documents.
Yeah, so each of the states have their own Electronics Transactions Act provisions. There's a Commonwealth version of the Act, as you see there, the 1999 Act. What this was done, I think, with Rule 30 is to make sure that it's clear that those provisions apply to the operation of the deed and the execution of documents within the deed. So there's no ambiguity. We've seen since COVID, some of the states continue with the electronic execution of various documents. Some states have pulled back, particularly around testamentary documents such as wills. And so because of that patchwork quilt, as it were, of different states having different procedures, I think Rule 30 here really makes it really clear about what can be signed as far as the deed's concerned.
Yep. And we've both done a lot of work here. So for our members that need to come in and potentially try and understand what can and can't be done, this is something, and Chris, your team had recently just sort of gone through and done a review of something that I'd done not that long ago, and you'll be able to then see the breakdown of at a federal level. So obviously the Corporations Act, and then within the relevant states, both in terms of the execution of deeds, along with any witnessing requirements as well, and by broken down by literally all the relevant states, and then the important dates that also apply in respect to the validity of when something has occurred, to ensure that if it has been done in an electronic means, that you've actually got that done and done appropriately as well. So that is available within our Smarter SMSF knowledge base. So our members and those that order can go into the knowledge base, and then it will take you across and you can search for that under the electronic signing requirements. All right, let's jump back into our slides again. And then, Chris, the other area here that we're going to now talk through is around decision making, and really understanding the importance of what decision making looks like within the fund. And then if we can't get to a decision, how we might then actually deal with a dispute. And we did touch on this a little bit earlier when we spoke about the fact that different deeds look at decision making very differently. So we may have a one-to-one scenario in terms of one person attending the meeting gets one vote, but we also know that when certain decisions are made, some deeds will develop it based upon the person that has the largest balance will in essence get the most number of votes. So the number of votes is equal, linked to the account balance in the fund. Within the Smarter SMSF deed, we do that. So we do link it to the dollar of account balance function. But probably the other thing that we want to talk about here is then, well, what happens if we get to a situation where there is a dispute around this, and therefore it does come back to what then happens next. And Chris, this is an area of expertise for you, so I'm going to hand over to you. I'm happy to sort of start on this page if there's anything else you're going to add, but yeah, this is certainly an area of growing interest, certainly within the legal profession, about how decision making is going, and therefore whether they've done the right thing. And this obviously is an important aspect around the payment of superannuation death benefits.
Well, like every deed will have different provisions dealing with dispute resolution or decision making, put it that way. Our deed obviously determines decision making based on account balance or the size of account balance. And I think that's quite appropriate where you have now funds with up to 6 members, right? And a lot of those funds will be families bringing their kids in. So it's only natural that the parents, as the patriarchs, will want to make those sort of key decisions. And so they're likely to have the larger account balances. But I think that because for self-managed super funds, we don't have a superannuation complaints tribunal to go to where there is a dispute, we end up in the Supreme Court with the significant costs involved. I think it's important that there be a mechanism, and there is a mechanism built into our deed here, which allows disputes to be resolved through mediation. As you can see there in Rule 27, there's a default provision there where a mediator is appointed to try and resolve the disputes, and that's a mandatory requirement before people can run off to court to litigate over a dispute. It's a prerequisite of the deed, and I think that's a sensible approach. I think one that suits a lot of members, and particularly in terms of cost, because the reality is that when you go through a court process, you're shunted off to mediation anyway.
Yeah.
But that's usually after you've spent a couple of $100,000 in legal fees. So what we've done is effectively brought that process forward. We know statistically through anecdotal evidence that about 90% of cases settle at mediation. Unfortunately, that's usually after they've spent a lot of money in legal fees. So the process here is to help bring or the intention here is to help bring that process forward as a mandatory requirement.
So, Chris, you're saying that we're actually putting the horse before the cart, whereas historically the cart has typically gone before the horse, and then they get sent back to put it back in order again. It
becomes a big full loop. And the only benefit of mediation through the court process is everyone spent a lot of money and they're more softened to the approach of settlement. But the process that the mediator would take through this process is exactly the same as the court mediated process. That is, the mediator is designed to identify the strengths and weaknesses of each person's case and to put the opposing position. And the opportunity here is to pick somebody who's going to be more in tune with SMSF issues and SMSF count balances, rather than just being shunted off through the court process to somebody who may have no experience about SMSFs.
Yeah, and it doesn't. Yeah, so if there is a position that can't be resolved, it doesn't. Then there is then obviously the next step that needs to occur. But I think, as Chris, you've rightly pointed out here, the fact is that we want to put mediation first, and then because history dictates that, I think you said 90% or whatever it is will get resolved at that point. So we're trying to preserve the financial interests of the members and beneficiaries with the money in the fund. And then if an outcome cannot be, successful outcome cannot be found and negotiated there, well, then they've got the natural next step of the courts to try and get a resolution that they would either be happy with or would have to be bound by.
Without this clause, you would have to get to a situation where both parties agree to mediation. And when there's a dispute, everyone's fired up. They're really passionate about the issues, and one party or the other will institute legal proceedings. But this process mandates everybody having to sit around the table. There is no option, and I think that's a good thing for everybody, for the reasons I've mentioned. That it's going to happen anyway, and it would save a lot of cost.
Yeah, absolutely. Well, let's sort of move on to our seventh and final one. And this is the importance of understanding how and why a deed has been developed in a certain way. And this is understanding that the trustees will be empowered to do certain things. So, because I think a common perception is that the deed should just enable everything to occur, and it's written in accordance with the law. But the law does not necessarily allow for things to occur. We actually, there are some things that are permissive, so by virtue of the Act and the regulations, and then there are other things that are prohibitive. And a really good example of that is something like the acquisition of assets from related parties and so forth. So if we have things that may be permissive but don't necessarily stipulate how that can occur, or they may be prohibitive and then there are some certain exceptions, then we are needing the deed to become the enabler to do that, and therefore to allow the adoption of those provisions or effectively enable something to occur. So, Chris, I might get you to sort of talk to this a little bit more, and also in respect to some of the more common examples that we see around this area.
Yeah, and look, it's been discussed, it's sort of at the pub talk sort of level. Why can't the deed just say, this deed follows the provisions of the SIS Act, right? But the fact of the matter is that the SIS Act, as we've spoken of, prohibits certain conduct and permits other conduct. Permitting it doesn't mean that it's empowered, a fund is empowered to adopt that. We need to effectively replicate those permitted parts of the SIS Act into the deed, and with some modification, right? To the extent that they're permissive, we don't necessarily have to follow it. But of course, Section 17A, as we just mentioned, the admission of an LPR is a permissive provision. It's not a prohibited provision. If the deed doesn't speak to that, then there's no obligation on the member to step down when they lose capacity.
Yep.
It's only if they want to maintain their complying status. There's no actual physical obligation. So we need to write that into the deed. Same with limited recourse borrowing. A lot of the banks will say, we won't allow you to lend money unless the deed actually empowers the fund to adopt Section 67A, right? So again, it's another example where the deed has to import certain provisions of the SIS Act and speak to it specifically with any modification to the extent it's not prohibited. Our fund guardian is an example where the SIS Act is completely silent. We brought it into the deed as a feature of one of the part of the permissive elements of the Act.
Yep. Yeah, so a couple of examples. So Rule 15 very specifically looks at trustee powers that enable, the trustees to undertake certain things at some of those areas, obviously, Chris, that you just spoke about. One of the other areas that we see quite commonly is about the powers required to be able to effectively carry on a business in the business of property development. So obviously we've just got that here in respect to the ability to undertake certain actions when it comes to real property there. And then there may also be examples that I spoke on the other slide here that we may be looking at a certain asset in a particular way to be holding for a certain purpose. It may be that we want asset concentrate, the requirement to have diversification. We might not want that by holding a specific asset and therefore not having that level of diversification required. So the power to actually do that in certain circumstances. So there are a range of things that we need to constantly look at based upon the relevant sort of position of the law and ensuring that the deed effectively empowers these things to actually occur. So Chris, anything sort of final to wrap up on that one?
Just that, that to the extent that the Act says that a fund must have an investment strategy, which it doesn't dictate what it has to say, the powers have got to meet with the investment strategy. So again, those two documents must speak to each other. But the fact is that the government and the SIS Act doesn't specify what assets to own. It just sets out those transactions and assets that are prohibited.
Yep.
Right. And that's why the deed has to flesh out and provide those powers to the trustee to do the things that the trustee may want to do as part of the investment strategy of the fund.
Yep. Very good. So anything else, I guess, as we start to wrap up? So I think, as I mentioned at the beginning, changes to legislation don't ultimately automatically result in a deed amendment having to occur. But in saying that, as things continue to change, it is important that you continue to review and understand at what point in time, what strategies might we be looking at, what things are occurring in the legislative space, in the legal space, that might therefore mean that we need to look at this more broadly for our clients. Prescriptive references, I think, are quite problematic here. And therefore, when we do see changes in the law, you're going to need to be more cognizant of those. So if it had a limitation around 4 members, and we saw the change in 2001 to 6 members, and then you're wanting to add family members in, well, quite clearly, you're going to have to make an amendment to be able to do so. Similarly, we've seen prescriptive references around downsizer contributions. Previously at age 65, that then moved to 60 and then moved down to 55. So again, subject to the timing of your clients maybe availing themselves to these sort of things as well. So from that point of view, just asking yourself regularly, do the trustees or members have any need to reflect what these changes are and therefore look to do those particular updates as well? So Chris, any other things there? I know we spoke about what's on the horizon as well with Div 296 earlier.
Look, I just want to make a sort of a closing comment that some advisors see a trust deed as a ubiquitous document. It's just buy it off the shelf. It's just one size fits all. And the fact of the matter is, and I think this presentation today should demonstrate that that's not the case. That having a deed which has the ability for you to customize the powers and the provisions of the deed to meet your client's circumstances is just another way of you adding better value or more value to your client and having deeper conversations with them about their family, their affairs, if they lose capacity or what happens on death. It enables you to have those deeper discussions and have a toolbox of options that allows you to develop strategies that best fits the needs of that client. And it's the deed that drives those strategies and those benefits. And that's just another way where you can show greater value to your clients if you adopt certainly a more holistic approach.
Yeah, and that's certainly to the reference on the right-hand side is that our value proposition has always been around our depth of knowledge and our depth of documents that sit within the SMSF space. And when we look specifically to the deed, it's it's the other elements that sit behind it. It's the 7 things that we've spoken about today within the deed itself, but it's then the ability to create special rules and the documents that sit behind that enable you to develop a pension document as a special rule of the fund, or the fact that you can introduce that concept of a key guardian role into the fund. So it's all these things that myself and Chris and a number of our clients all talk to regularly to think about where the law is at, where the law might be heading, what cases are being going around. And it's not only the deed itself that, Chris, you were talking about, but it's going, what else do we need to do that is strategically advantageous, but will ring fence certain events that may or may not occur in the future as well?
Yeah, and I think that the deed is like your toolbox, right? And and we're here to show you how to use the tools for the maximum benefit in the relevant circumstances, which is your client's affairs. And education is the key that sits over the top of that, which is what.
Absolutely. So I guess just wrapping up here, in terms of the documents and stuff, so Smarter SMSF, we do own the deed and all the document IP that obviously sits around that. Ian Glenister, who's now retired, was the person that the genesis of where this all was developed originally, still is a shareholder in the Smarter SMSF business. But we now at Smarter SMSF utilize Chris and his team at Hill Legal for all the legal sign-off that we need in respect to these documents. I know, Chris, you and I have been working on this deed since those law announcements happened in 2016, and we spent many days sort of looking at the impact of those changes and so forth as well. And therefore you have that confidence that we're not only looking at this in the context and opportunities that the SMSF and superannuation laws more specifically deal with, but then we've got that legal oversight that's really giving you the confidence to be able to utilize these documents. The fact that the documents are regularly updated. So yes, we update it once a year, but we're probably updating it more than once, noting again the currency of the information that we have, not only on the document side, but obviously through the education that we do more broadly as well. And the other thing that we've talked about and we'll be talking about in more detail tomorrow is the fact that if you are ordering certain documents, you do have that legal review. So our Smarter Legal Review is available that gives you that legal sign-off provided by Hill Legal if you're wanting to update deeds, or you may find that you've got a deed that may need some form of rectification and requires that to occur before you can then go through and do that update that would be required as well. So, Chris, we're going to wrap up here with just a few final questions here. I think we've answered a couple of the more recent ones there. A common one we get is, what happens if the client has a missing deed? So I'll get you to give some fairly short, sharp answers there.
Well, if you have a missing deed, we need to have one. We need to have it. We need to adopt one. It closely aligns with the provisions of the original deed. You can't not have a deed. So we would adopt one and through a deed of adoption if necessary.
Yep, absolutely. Circumstances where we have additional parties to our deeds. So quite often we might find that there's a founder or a principal employer, that sort of thing. One of the common things we talk to clients about is whether that role needs to continue. So what sort of things could we be, I guess, contemplating there?
Yes, I mean, obviously, continuing with a deed. Sorry, continuing is or having a process for when the fund is to continue and who's going to take over control is going to be part of the operation of the fund. It's going to be found in the fund's deeds.
Yep. So if we had a situation though, if we want to get let's say there was a principal employer, someone sold the business, there is quite clearly opportunities for in part of a deed upgrade process to remove particular parties from that process that may be, above and beyond the member trustee or member director relationship that is ordinarily a party to a modern day SMSF deed.
Yeah, and we can do that if the principal sponsor doesn't have to have a say in the amendment of the deed. Right. Yep. So that's critical to know. And that's why it's important to drill down into the provisions of the deed to see you know, are they now obsolete, and do they and how do we remove them if they're and is their removal going to impact on the validity of the deed upgrade? That really comes down to just reading the provisions of the deed.
Yeah, absolutely. I think we've kind of the last one there, or the second last one, how often you might recommend updating. Again, a lot of that is going to be subject to the type of client that you've got and the strategies that you might be employing. Having a look at the slides when we provide them to you after today's session, you'll get a bit of an insight, like I said, from those decades, I guess, of the changes that we did see. In my view, there's been a significant number of changes since 2017 that are at least worth considering going back and revisiting for your clients, even if we look specifically at the electronic execution measures and the Hill and Zuda decision are just two that really come to mind very quickly. And I guess the final one there, in terms of the ability to automatically update deeds, we do have the power within the deed to enable that automatic update service to occur. It's something that we do have close to finalising in our build. It's sort of taken a bit longer than we wanted to, but if you wanted to look at the opportunities for the fund to adopt an automated update service, that capacity will be available shortly as well. So, Chris, that pretty much takes us to the end of today. As I said at the very beginning, this is part of our more broader Smarter Legal Week. So Chris and I will be here at midday Australian Eastern Standard Time, not only today, but for the next 3 days as well. We do have a bit more about the Smarter Legal Review process and why it's important to consider around situations whereby you want that legal sign-off in respect to whether it's a deed upgrade, or you want to understand the process of how you can remedy particular defects in documents. We'll be looking at the ability to utilise, from a succession point of view, in our other two sessions, the requirements around enduring powers of attorney, and specifically Chris has done some fantastic work around the development of an SMSF power of attorney, available only under the Smarter SMSF deed. And then on Thursday, we'll be looking at the role of the fund guardian, and again, more detail as to why we see that as a hugely important role, not only in the succession, but for you as a professional advisor to be able to work with your clients and charge a relevant fee for that role in respect to the ongoing succession of their clients as well. So, Chris, to you, thank you very much for joining me with today's session.
Thanks, Aaron, and to our viewers. We look forward to catching up the remaining sessions.
Yeah, absolutely. Now we've got, just going to have a look at a couple of any final questions here. So one of the things here from Steve Rowley is he asks, if you update to a current deed, do you automatically have to renew the death benefit nomination? So I guess specifically, does a deed upgrade invalidate any previous nominations that may be in play?
It's a good question. It does depend on the terms of the previous deed, but I think it should certainly be reviewed, because the form of nomination may not conform with the provisions of the upgraded deed, right? Our deed in particular. So the upgrade of a deed should trigger a review. I mean, it may be validly made under the terms of the previous deed, but invalid under the current deed. But of course, the previous deed's no longer valid once you upgrade. So you've sort of jettisoned that deed. So I think that's a good opportunity to review the nomination, because it could become invalid.
Yeah, I think, Chris, from memory, our deed of variation says that if you had something previously, it wouldn't invalidate what you've got. But as you've rightly said, it would make sense to give due consideration to why or what they actually have in place in the first instance.
Yeah, because the death benefit nomination may not even conform with the old deed.
Yes, correct.
So it wouldn't be saved by the variation. So it's probably it's good practice to review. Let's put it that way.
Yeah.
And in the context of our discussion today about how do you best serve your client, whether that form of nomination is still appropriate today.
Yes, absolutely. Yeah, 100%. So, because like it could be that it's lapsing, Could be that there's additional requirements for it to be accepted, and whether all those things have been followed in the first place or not.
Yep.
Absolutely. All right. Well, thank you everyone once again for being a part of today's session. We hope you found that valuable. Like I said, you will get a copy of the slides after today's session as well. We do have a survey that we do ask you to complete just to give us some feedback around the value from today's session and what else you might want to hear from us in respect to the topics that we're running this week. So thank you all, and we look forward to hopefully seeing you again tomorrow, where we talk a bit more about the Smarter Legal Review Service. Thanks, everyone. Take care, and bye for now.